You are welcome to Gwungmijana's Legal Discourse. My name is Gwungmijana Festus Ogichi, and this video is for my Criminal Law 2 series. Whether or not this is your first time to this channel and you have not subscribed, please do so. That's what keeps this endeavor going and moving. Thank you for doing that. Let's go to the main business or topic for discussion. In this tutorial, the topic for discussion is sexual offenses. Sexual offenses. However, we shall start with one for today. As you can see from the topic, offenses, meaning it is more than one, but for the purpose of today's tutorial, our focus is on rape. Rape. That's the topic for today under sexual offenses. Rape. Rape. Now let's begin the discussion on rape. The focus and what you should expect from this discussion is that at the end of this discussion, you should be able to define or know the meaning of rape, know the elements or ingredients of rape, and also know those who are incapable of committing rape. Basically, under the criminal code, because my discussion of rape in this video is based on the criminal code. So those are the objectives of the study or expectation. Let me see if I miss any of the objectives of the study. Yes, those are the things you should be expecting from this study. Now, by way of introduction, it may interest you to know that rape is the most serious of all sexual assaults. The assault can be sexual in nature or it could be non-sexual. So sexual assault are assault that are of sexual character that pertains to a sex. So among all the sexual assaults, rape has been considered the most serious. It is a very serious matter, as the perpetrators are sometimes considered to be animalistic. They are animalistic, those who indulge in these acts. So that's the first point by way of introduction, that it is the most serious, the most grave of all sexual assaults. Now, what is rape? As I did mention, there are the focus of this discussion is based on the criminal code. However, there are other laws dealing with rape in Nigeria, like the penal code and the Violence Against Person Prohibition Acts and others. The ingredient and definition of rape under all these various laws are virtually almost the same, apart from the verb, the Violence Against Person Prohibition Act, that actually expand the definition of rape. But our focus with respect to this topic is rape under the criminal code. What is rape according to the criminal code? Fortunately for us, rape has been defined under the criminal code. Therefore, we should not wander in the wilderness or beat about the bush looking for the definition. We shall hear from the authority, the principal authority with respect to this topic and cause, which is the Criminal Code Acts applicable in southern Nigeria. So rape is defined in section 357 of the Criminal Code. And how is it defined? Before we see the section, let me actually try to explain what the section is saying, so that by the time we see, you can better appreciate and understand it without racking your brain. By virtue of that section, rape is simply a non-consensual sexual intercourse. Sexual intercourse without consent. So rape is when you have a carnal knowledge or sexual intercourse of a female. A female in this respect could be either a girl or a woman without one, a consent. That's the first part. One, without, if you do it, you penetrate, you insert your penis into the female vagina, without a consent. That's one. Or even if you do it with consent, but the consent was not voluntarily given, you do it with by obtaining the consent, you obtain it by force. If you obtain the consent by force or by intimidation or by a fear of harm, it is also rape, because that consent is no consent in law, since it was obtained by fraud or by intimidation. So that is just what rape simply means under the criminal code. When you go into the vagina of a woman or a girl and you do that without her agreeing to it, that means it is usually by force or by intimidation. When you do that, you have committed the offense of rape. When you do that despite her resistance, when she did not want it, but you force her and do it, that is rape under the criminal code. So the important thing is having a carnal knowledge or sexual intercourse with a woman without one, a consent, or even if it is consent, when the consent is not voluntarily given but obtained by unlawful means. So it is an unlawful sexual intercourse with a woman. Unlawful, a sexual intercourse that is against the law, that is contrary to law. Let's actually hear from the horse's mouth. Let's hear how the criminal code section 357 put it. Section 357 states thus: any person who has unlawful, underline the word unlawful, carnal knowledge of a woman or girl without her consent, or with her consent if the consent is obtained by force or by means of threats or intimidation of any kind, or by fear of harm, or by means of false and fraudulent representation as to the nature of the act, or in the case of a married woman, by personating her husband, is guilty of an offense which is called rape. So you can see the provision that it is not quite far or different from what I've explained thus far, that any person who has unlawful carnal knowledge. So the carnal knowledge must be unlawful. And as we shall proceed, we shall know when it is said to be unlawful. In fact, it is unlawful when the person is not your wife. So if you are having if you have carnal knowledge of a person who is not your wife in the manner provided thereunder, that is, if you have carnal knowledge of a woman or a girl who is not your wife, that is when it is unlawful without a consent. When you do that without a consent, or even if you do it with a consent, if the consent is obtained by force, she later submitted, surrender, agreed because of the force you applied, or by means of threat, you threaten her. If you don't open, I'll fire you. Or intimidation of any kind, you intimidate her, or by fear of harm, or by means of false and fraudulent representation as to the nature of the act. Even if you fraudulently represented that what you wanted to do was not a rape, and with that you get a consent because you make a fraudulent representation. Or in the case of a married woman, by personating her husband. So if you personate the husband of the woman and penetrate, then you are also guilty of rape. Is guilty of the offense called rape. So what the provision is saying, that it is an unlawful, and I've said that unlawful means that you are not the husband of the girl or the woman, and you have a carnal knowledge of her without a consent, or with a consent if it's obtained in the manner provided in that section, then that is rape. You have committed the offense of rape. Now let's proceed by looking at the elements of rape. Elements of rape. Elements or ingredients of rape. So the elements or ingredients are what the prosecution must prove in order to sustain the conviction of the accused. So what must the prosecution prove? Or what are those things that when they are available, then rape can be said to have been committed? Those are the elements or ingredients of rape. The element or ingredient of rape, the key element is penetration. So the prosecution must prove that the accused or defendant penetrated the vagina of the woman or girl. Another element is lack of consent or absence of consent. The prosecution must prove that it was done, the penetration was done without the consent of the woman or the girl. These are the elements of rape. But the court in the case of Posu against the state actually outlined the comprehensively and exhaustively the elements of rape. So in that case, the court outlined and listed the elements of rape as follows. Let's hear from the courts. In the case of Posu versus the states, the element we are outlined thus: that the prosecution must prove one, that the accused had sexual intercourse with the prosecutrix, that's the victim. Two, that the act of sexual intercourse was done without a consent, or the consent was obtained by fraud, force, threat, etc. That's two. Three, that the prosecutrix was not the wife of the accused. So the prosecution must also prove that the prosecutor was not the wife of the accused. Just like I said, that unlawful means that the girl or woman is not the wife of the accused. So the prosecutrix the prosecution must prove that. Also, 4, that the accused had mens rea, that is, intention to have sexual intercourse with the prosecutrix without her consent. So the prosecution must also prove the mental element, and the mental element is that the accused had the intention to do that, to penetrate the girl or woman without her consent. He premeditated it. Then finally, that the prosecution must prove that there was penetration. So these are the elements that the prosecution must establish in order to secure the conviction of the accused, as outlined in the case of Posu against the states. However, the key element there is actually penetration and lack of consent. So once these two elements are proved, then the other elements will actually be implied. So these are the two elements. We shall now consider what they entails and what they require. So the first one is, let's look at penetration, the elements of penetration. Penetration as an element or ingredient of rape. Penetration is a very important and essential element of rape. It's very sacrosanct. In fact, there can be no rape without penetration, because rape is actually complete upon penetration. It is if the accused have intention to have intercourse or carnal knowledge of the woman or girl. If he just nots the thought in his heart, and he has not actually do so by penetrating, then he cannot be guilty of any offense. So until he penetrates, that is when rape. He penetrates without the consent of the woman or girl, that is when rape has been committed. So there must be penetration before rape will be complete, and this by virtue of section 6 of the criminal code. Section 6 of the criminal code, which provides when the term carnal knowledge or the term carnal connection is used in defining an offense, it is implied that the offense, so far as regard that element of it, is complete upon penetration. You can see that when the word carnal knowledge is used in defining an offense, and in defining the offense rape under section 357, the term carnal knowledge was used, and carnal knowledge is complete. Someone is said to have carnal knowledge of somebody when he penetrates. So carnal knowledge, the element of carnal knowledge here is penetration. So once you penetrate the vagina of a girl or a woman, then you have had carnal knowledge of her. So penetration, carnal knowledge is complete upon penetration. It is when you penetrate, then you have had a carnal knowledge. So penetration is very important. Now, a court, the word penetration has actually been defined by in a particular case. Let's see how the court defines penetration in the case of Inse Udo against the state. In Inse Udo against the state, the court actually defined penetration. Let's hear the court in that case. The court defined penetration thus. Penetration means passing into or through. So when you pass into or through, you are penetrated, often by overcoming resistance. Let's say, so you pass into through resistance. However, most importantly, the court further pronounced, in the context of criminal offense of rape, the court now defined penetration in relation to rape, that it is to insert the penis into the vagina of the prosecutrix. So you can see how simple the court defined penetration in this case, that in the context of offense of rape, penetration means to insert the penis into the vagina of the prosecutrix or of the victim of the rape. So when you insert your penis into the vagina, when the accused inserts his penis into the vagina of the prosecutrix, then penetration has taken place. So there's a penetration. And now the question is, when is rape said to be complete? As I've mentioned earlier, rape is complete upon a penetration. Rape is complete upon penetration. So once you penetrate, after nursing the thoughts and you penetrate, then rape is complete. However, the judgment of the judgment of Scammer J in Arrow versus Mabry, according to the judgment of Scammer J in Arrow versus Mabry, it stated that the acts that precedes or that comes after penetration is still part of rape. There is the act such as ejaculation that comes after penetration is also part of rape, and that any assistance given to the accused after penetration will constitute aiding the crime of rape under section 7 of our criminal code. There's the judgment, the dissenting opinion of Scammer J in Arrow versus Mabry. The next point is, what extent or degree of penetration is required for there to be a penetration. So, to what extent or degree will the accused penetrate before it can be said that there is penetration? Can the accused be able to complain, "Oh my lord, I did not go too far. I did not penetrate deep. It was just, it was not even up to an inch"? Does the accused need to penetrate everything? For instance, if it's only 6 inches, does the accused need to insert deeply, and does he need to penetrate all the 6 inch before there can be said to be penetration? How far should the accused go into the vagina, the scabard, the sheet for there to be penetration? How many inches? What is the measurement? Well, the question has also been answered for us by the court in that case of Posu against the state. And let's hear what the court have to say. This is what the court states: any or even the slightest, underline, that's the important word, the slightest penetration will be sufficient to constitute the act of sexual intercourse. Emission or rupture of the hymen is not necessary to establish the offense of rape. So the degree of penetration or the extent of penetration that will constitute penetration is slightest, the slightest. Once it just enter, once you just put the key into the padlock, it constitutes penetration, and the prosecution does not need to prove that that there was the rupture of the hymen, or to establish that there was emission. The important thing that will constitute penetration is the slightest one. Any slightest touch, that is penetration. So there's a that on penetration as an element. I've defined penetration, what constitutes a penetration. So I shall stop the discussion here and continue the other element, which is absence or lack of consent, in the next video. Thank you. Please don't forget to subscribe, like, share, and comment. See you then.